Today on Law Weekly, we revisit the issues of the slow pace of justice administration in Nigeria. Former president of the Nigerian Bar Association, Olisa Agbakoba, is one person who is doing something about this. He calls it the Speed of Justice Project. Plus, the Nigerian Institute of Advanced Legal Studies celebrates its 35th anniversary. One of the highlights of the celebration was the presentation of the Institute's Award for Media Excellence to deserving media houses. Channels TV and its judiciary correspondent were among those honored at the event. That's the lineup for today's program. I am Shola Shoyeli. Details in a bit. The Speed of Justice project is designed to ensure a quick case flow in our justice system. That's according to former NBA President Mr. Olisa Agbakoba, who says he's very concerned that the public perception of the judiciary is not exactly as expected, which can be attributed to the delay in the justice system. Recently, we had a chat about the issue.
I've written to the CJN. I have written to all the CJs of 36 states. I have written to the president of the NIC, National Industrial Court, and to the president of the CJ of the FCT. Okay. Just saying, let's use this here to review how lawyers and judges work in the judicial system. And I just gave a number of examples about how we can make more progress. For instance, I said in the letter, without looking at the subject very closely, must a judge actually deliver a decision in open court by sitting down?
So all that 3 to 4 hours of reading their judgment, you think we can do away with it?
Clearly. I mean, in the Court of Appeal and Supreme Court, that is now part of the standard practice. Okay. So I remember once in Justice Oyewale's court, when he was assigned as one of the EFCC judges, 5 hours to read the judgment. That's waste of judicial time. I'm not blaming him, because that's the culture. I remember when Justice Abutu was dealing with the Hebrew EFCC applications for bail. He sat from 9 till about 5 p.m. There were about 17 senior advocates. There was no concern for case management. And everybody droned on and on and on. So little things can create change. I'm always concerned about why we lawyers have to send our registrars to the registries of the various high courts and wait in line to pay cash. Do you know how much cash is paid into the Federal High Court registry every day? And even the danger of somebody coming with a gun to steal the money. Sometimes the receipts are not enough, so they will bunch 10 cases under one receipt, and we go and make photocopies. Come on.
So that everybody gets a copy of the payment.
Absolutely. No, we can do things that it's little changes will have an impact on the larger judicial picture and make us go faster. So one, the way we file, I think has to change. We should be able to file online. Every lawyer should every year renew his online registration with the courts and then pay for that service. So if you have a case, you sit in your chambers, type out your claim, you file, and you paid.
So there is already a process in place to do this, just that we're not doing it.
Yeah. When I amended the Federal High Court rules for Justice Ukeje, I inserted Order 58, dealing with communication systems, communication center, but it has never been activated. Okay. So there's a system in place to actually modify.
Is that system in place also at the State High Court?
No, it isn't.
Okay, so they should introduce this.
They should introduce. But if we all agree to look at the problem in all our different ways, the lawyers, the judges, then you will find that just changing attitudes. For instance, when we go to court and a matter would not advance or a judge would not sit. Registrar, judge is not sitting. Take dates for mention. Yes. I remember years ago in the Demola court when the Court of Appeal was in Bodilon, and one of the very senior advocates requested a date for mention. He was politely told that there's nothing like mention. Mention is that you are not coming to work. So the culture of mention absorbs 30% of wasted judicial time. Has the vice chair of the NGC's, no, not the the stakeholders committee set up by the former CJN, when he set up a stakeholders committee to look at the judicial process, I was the vice chair of the Committee on Speedy Dispensation of Justice. We found that 70% of cases are frivolous.
This was how many years ago?
This is too long ago, under Mustafa,
Okay.
CJN. So Mustafa retired maybe 18 months ago, I would say. It's a shame that we didn't carry on from that, great, innovation that he introduced. But I was very shocked. 70% of cases. And there's always this argument between lawyers and judges, who is at fault for causing the delay. The judge is master of his court. So he's the one who to manage the courts. I remember the best example of judicial speed that I've seen concerned a municipal house that was owing money, and therefore an application in the nature of bank winding up was brought. But the judge said, look, I know that this municipal house may be owing you, but it's a going concern. Therefore, the application to wind up failed. The case was dismissed. 10 minutes.
10 minutes.
Other judges will say, all right, come back, Some judges will see big volumes of law books and not ready to work. So we need to find new strategies to unbundle the work of judges. And hopefully this Speed of Justice project will appeal to the CJN, to the CJs, and we can get it going.
You've talked about the NJC, the CJN. What essentially do you want all these parties to do? How do they get involved in this Speed of Justice project?
What I want them to do is to understand that the operating model of the courts, that's the rules and the other protocols, are too old. Okay. Number one. Number two, the judicial and legal culture of managing cases, both in terms of presentation by lawyers and adjudication by judges, is outdated. In England, is the medical surgery approach. No judge has the chambers. Judges have their own chambers separate from their courtrooms. So you can have the Apapa division of the Federal High Court, 40 hearing rooms. You don't know who will come to the surgery. It could be anybody. He comes, everything is front-loaded. So he hears you and he treats your case, and it's like a continuous turnover. But when judges sit in their chambers, have their courts are next to the chambers, it even doesn't allow enough judges to be appointed, if that's a problem. So with this stuff in England, for instance, the Supreme Court sits in a room just as big as mine. They don't sit robed, they sit dressed like this. Mm-hmm. So this ceremonial high bench also causes delay. There are lots of things that can be done by the exchange of documents between counsel and the judge is intervening. In other words, if we introduce the arbitration model into adjudication, we will pick up a lot of speed. To amend, for instance, can you believe that to amend sometimes a court document can take a year? But if the court has power of its own volition, what we say suo motu, and another problem is language. All the suo motu and that must go. You must simplify. My lord, I want leave to. Leave to what? Just say permission to. Okay. Simplify the language. Make it easy for everybody to understand. Converse in simple terms. And judgments must not be overloaded. In the NJC, Justice Ayola is the chair of the Performance Evaluation Committee. One of the greatest obstacles to delay is that judges don't have enough time to write judgments. You know why? It's because in their minds, there's a mindset about how to write it. Somewhere along the line in the 70s, the judicial system got it wrong. It felt that judgments would have to be tomes, 20 pages, 30 pages, 40 pages.
That's because of language too?
Because of language and style. Okay. So now you will find the judge will copy out the claim and defense, copy out the evidence, copy out the... How many witnesses were called? Everything that happened in the case. Then summarize and give judgment in 2 pages. Yes. In the old days, that was necessary. The judge would just evaluate the case, and give his judgment in 3 pages. So he was able to deal with a lot more cases than judges do, because...
But what happened? How did we go back?
I don't know. I don't understand how we went back. I don't understand how we slipped. So that's part of what, the Speed of Justice project is designed to achieve. Is it always necessary to... Can't you give a bench ruling? These cases are very simple. You hear a case, the witness has, spoken, given evidence in court. The other side has given evidence in court. You can have, but if you tell the average judge, you say, no, I must go and reflect.
Because I even find that simple things such as even giving bail, judges would go back and say, come after 3 days, when it's something they could decide on the spot of the moment. And some judges do that. Yeah. But some others will say, okay, adjourn for 3 days, let me go and consider whether I will give bail in an offense as ordinarily bailable.
Absolutely.
So
that's part of the...
Why do we go back and forth?
Well, that's part of the problem.
And there's no uniformity. One judge will do this, another will do another thing.
That's part of what I hope will happen in the Speed of Justice project, that, with training, with seminars, with continuous education, that judges will come to see that the principles upon which bail is granted proceed on 3 tracks. So there are some types of bail applications in which the judge mustn't grant bail. Another where he has to grant bail. Another where he has a discretion. So if I was a judge, I would ask, prosecutor, this is a simple offense. I'm going to grant bail. Tell me why I shouldn't grant bail. That's all. The principles upon which bail is granted is settled in many cases by the Supreme Court. So it's clear to everybody. So my point is, can we identify all the clogs in the wheel of justice and see how many we can remove? This cash payment thing is 1. The way cases are filed, 2. The way cases are assigned, 3. The way cases are managed by the judges, 4. That one is very crucial, because the judge is, as I said, master of his court. So you should be able to say to Olisa Agbakoba, please don't make this argument.
Don't waste the time.
I can see that there's an error on the face of the pleadings, but I'll correct it. And you should have read Oceanic Bank. It reads Oceanic Bank. I know it's Oceanic. And you want to make an issue of it. You ask him.
You don't need to take an adjournment.
Then take an adjournment, or you are... Yes. And then the way cases flow. For me, a judge, once the case is flowing, no interruption. Anything that you want to object to, just note it. My Lord, I object to admissibility of this document on the grounds of, please. I remember once I came before Justice Adeniji over an accidented car, and I had to tender the vehicle license. So the objection, to just say, to what are you objecting to? That this is the photocopy. So the original will be in the car. This is an experienced judge.
Yes. So even the judges have to be on top of their
absolutely.
They have to know what obtains.
Yeah, absolutely.
And follow the trend too.
This is it. We need modern judicial, attitudes. So that's what I think will be good. Because at the end of the day, those who suffer are those who use the courts. Yes. I mean, a guy will be in jail. I remember when a guy came to see me and was saying that so-and-so had been 4 years awaiting trial for writing the bounce check because the chain hasn't let her visit the courts. That's terrible. It has to happen to somebody to understand how bad the system is.
So the way to contributing to resolving the judgment is perhaps a meeting of all stakeholders, or what? What are the specifics of how everybody gets to contribute?
Well, you see, the fact is that I'm just a lawyer, so it will require the cooperation of the highest organs of the judiciary. And that will be the CJN, the NJC, the NJI, the NBA, and incidentally, I've been in all of these processes. So I think what is important is to prioritize it, is to advocate upon it, and I'm prepared to do that. So once we have that cooperation and the energy is released, I think the problem will be solved.